Okay, class is being recorded. I will shortly, hopefully by tomorrow, upload all the recordings of the classes we've had so far on YouTube, so that you can listen to them. The study notes, the notes are on e-learning, and I will also from time to time share my class notes, my lecture notes that I make while I'm teaching with you, but I'm not going to do that after every class. Let me share my screen. Okay, thumbs up if you can see the screen. It's the document that I was used to type on. Just give me a thumbs up. Okay, thank you so much. Right, let's carry on. Let's see how far we get tonight. We're a little bit behind schedule, but I will work in extra classes as and when necessary to make sure that you don't lose out. Okay, so we're busy looking at the law of contracts. We did a little bit of introduction to law. Let's skip that. We're busy looking at the law of contracts. Reason why I'm going slowly at the moment is these first units. Law of contract covers, let's check quickly, units 2 to 7. So these 6 units form the foundation of the rest of the course. We do introduction to contracts, the basics of contracts, and then we look at certain specific contracts like purchase and sale. But these principles that I'm teaching you now also apply to purchase and sale, agency, lease agreements, etc., etc. So it's vital that you understand what we're doing now, which is why I am going slowly. So we learned that a contract must be valid. And there are 5 requirements for a contract to be valid. Now, all 5 those requirements must be present. Otherwise, the contract is void. And there are no obligations that arise from a contract that is void. Please make sure that you understand the concepts of valid, void, and voidable. Valid, void, and voidable. Please understand them. It happens too often that we get to end of semester exams and suddenly I realize that the students don't understand the concepts of valid, void, and voidable. That is tragic and it's going to make you fail. A contract is either valid or it's void. It is never both. A voidable contract is a contract that is valid and remains valid but can be set aside because something is wrong with one of the requirements, specifically the contract of consensus. But if one of the requirements is not there at all, the contract isn't voidable, it is void. Please make sure that you understand this. Then we looked at consensus. Now, consensus is integral to a contract. A valid offer plus a valid acceptance gives us consensus. If there is no consensus, there is no contract. But it could happen that the consensus was based on misrepresentation, for example, or duress or undue influence, in which case the contract is valid, but it is voidable. It can be set aside. So let's move on then to look at the other requirements. Because much as consensus is integral, you cannot have a contract without consensus. Consensus on its own is not sufficient for a contract to be valid. You need the other requirements as well. A possible exam question that I can ask, or test question that I can ask, this is what I refer to as a distinction question. Always bring in 1 or 2 for a couple of marks in my tests to separate I'm passing the course students from my distinction courses, of my distinction students. If you can't answer them, there will be enough other questions that you can still pass. It won't make you fail, but it will set you aside. So a distinction question. For 3 marks. Consensus is the most important requirement for a valid contract. Is that statement true or false? And explain why you say so. I'm not going to give you the answer to that question. You are welcome after the class to share your possible answers on the group, and I will guide you. So let's move on to contractual capacity. Contractual capacity, in a certain sense, is closely related to consensus. Consensus, we have learned, is a complete agreement and understanding. Let's get the requirements here. A serious intention to create legal obligations. You must be aware of the legal consequences. Consensus, a complete agreement about the same thing, the same understanding about the subject matter and the obligations. Now, closely related to consensus is contractual capacity. Contractual capacity relates to the issue of, can a person understand the significance of his or her actions? Consensus is a complete agreement about the context, content, and about the obligations, about the consequences. If you do not understand these consequences, you cannot truly agree to them. So contractual capacity deals with whether a person is regarded to be able to understand. Now, there are 2 aspects. There are others, but we just look at two aspects that affect your contractual capacity, namely age and your mental health. Your mental health, your mental condition. Now, with regard to age, there are certain legal rules. Under the age of 7, you are regarded to have no contractual capacity. You cannot enter into a contract. Parents will have to represent you. Under the age of 7, you are deemed not to be capable of understanding the consequences. Between 7 and 18, you have limited contractual capacity. Limited contractual capacity, that means you can enter into a contract, but you need the assistance of your guardian. There are certain exceptions like consent to medical treatment, etc., etc. We do not study those in detail. In general, between the ages of 7 and 18, you have limited contractual capacity and cannot enter into a contract. And then obviously over the age of 18, age of majority in Namibia is 18, you have full capacity. So that is age. But people that are over the age of 18, there are certain factors that can influence their contractual capacity, namely mental incapacity. If somebody is deemed by the court to be incapable of making their own decisions, they can apply to the court to have them declared insane. I don't like the word insane, but our textbooks still use that. So I'm going to change this terminology slightly. So, but this is not, remember, it has to be a court order. Mentally incapacitated. So it's not just that the other people think you're not capable of understanding or whatever. They have to, the people that want to have you declared incapacitated have to bring a formal application to the High Court of Namibia with the necessary documentary proof, medical reports, etc., etc. So if you are mentally incapacitated, then you have no contractual capacity.
Go back.
Miss Matthews, please, your mic, your mic, your mic.
Is it me?
Can we have our mics muted so that we don't have background noise? You feel free to put your mics on and interrupt me if you have questions. But otherwise, let's not have people chatting in the background. So in any event, if there's a court order declaring a person mentally incapacitated, they have no contractual capacity. It could happen, however, that these people still have a clear moment. And during that clear moment, they might understand what they were doing. So how it works is that if a person to hold them to a contract, that person must prove that they had a clear moment. In all other instances where somebody above the age of 18 claims that at the time of contracting, they did not have contractual capacity, that can be, and specifically, we discuss it in the study guide, paragraph 1.3. But it's not only applicable to intoxicated persons. The same concept will apply, for example, if somebody suffered an injury, suffered a severe concussion, they can be temporarily mentally incapacitated and therefore not have contractual capacity. In all these, so let's not limit it to um, to just intoxication. Let's take it wider. People that are mentally incapacitated, alcohol, drugs, injury, whatever. The person who claims that they did not at the time of contracting must prove this. So just to reiterate, make sure you understand, everybody above the age of 18 is deemed to have full contractual capacity. There can be circumstances where, due to whatever reason, injury, intoxication, whatever, that a person does not at the time of contracting have the capacity to understand their actions to reach consensus, and will therefore not be bound to the contract will be void, but the person claiming this will have to prove it. Unless this person has been declared incapacitated by an order of court, then it is the other way around. They don't have to prove anything. Whoever wants to hold them to the contract must prove that they understood. Any questions about this? Okay, moving on then to, let's copy and paste here so that you can keep up. So we've looked at consensus, we've looked at contractual capacity. The next requirement then is that performance must be possible. There are two aspects to the requirement that performance must be possible. In the first instance, performance must be possible in the sense that the parties to the contract must know what to do. It must be determined or ascertainable. Ascertainable, it might not specifically be fixed, but you can find out what performance is required. So either fixed or easy to figure out what has to be done. If you don't know what has to be done, obviously performance is not possible. And secondly, it must actually be possible. Must be physically possible. With regard to the second requirement, that the contract must be possible, what we're referring to here is that the contract will be void if performance is objectively impossible. So you need to, with regard to that requirement, that the performance must actually be possible, you need to distinguish between objective impossibility of performance and subjective impossibility. What is the difference between the two? A contract will be void if performance is objectively impossible, which means that nobody can perform. The silly example that I normally use to illustrate this is a contract to mine diamonds on the moon. Currently, diamonds cannot be mined on the moon. So if I enter into a contract with, let's see, who do we have here? Fanny, that I will sell her all the diamonds that I can mine on the moon. That contract will be void because my performance, the delivery of these diamonds, is not possible. So that is objective impossibility. I can't mine diamonds on the moon. Fanny can't mine diamonds on the moon. Taimi cannot. Narisha cannot. Queen cannot. Nobody can. Subjective impossibility of performance, on the other hand, relates to a particular contracting party. So the particular contracting party cannot perform. So let's say that I buy a cell phone from Fanny for $1,000. And the day before I have to pay her, my purse gets stolen and I no longer have $1,000. I cannot perform because I don't have the $1,000 to pay. But timing would be possible, or Elvianus, or Queen, or whoever. Somewhere in the world, there's somebody that can pay $1,000. I cannot. So this is subjective impossibility of performance. The contract remains valid. Could be potential breach of contract. We'll get to that at a later stage. If I have to pay and I don't pay, then I might be in trouble for not doing what I'm supposed to do. The contract remains valid. If nobody in the world can perform, the contract will be void. Questions? Okay, our next requirement. Performance must be legal. That's fairly easy to understand. There's not much there that I have to, or much here that I have to explain to you, except the concept of the contract must be legal goes a little bit wider. So not against the law. So either common law or statutory law. Remember the difference between common law and statutory law? Just give me a second quickly. So I hope you remember the difference between common law and statutory law. Contract must not be against the law, not against the common law or against the statutory law. But also what is at the time regarded as good morals. So a contract must not be against the law. Easy example of that, selling of drugs, selling dacha or cocaine or whatever is against the law. Dealing in unlicensed firearms, that is against the law. On the other hand, contracts that are regarded against our good morals. Let's say I enter into a contract with Alvianus that I will pay him $500,000 to marry my daughter. That contract will similarly be void because paying somebody to enter into a marriage is regarded as against our good morals. When it comes to so that's fairly easy to understand. There is one aspect here that I need to stop at. This is on page 25, which deals with contracts that are against the law, that are void because they are against the law, because performance is illegal. But we need to look at a contract in restraint of trade. Contracts in restraint of trade are interesting. I also have a tendency to ask them in the exams. So make sure you understand what the issue is with a contract in restraint of trade. So firstly, what is a contract in restraint of trade? Contract in restraint of trade is a contract that prevents somebody, one of the parties to the contract, from performing doing a certain job for a specified time within a specified geographical area. Definition that we have in the study guide. Oops, that's not what I wanted to do. I was trying to copy and paste here. Contract in restraint of trade, an agreement that restricts the liberty of one or both of the parties to engage in one or more specified commercial activities for a specified period or within a specified geographical area. These are quite common. You will often find them in contracts of employment. Somebody offers you a job in a specialized field, and part of your employment agreement is that if you resign from them, you may not do a similar work for a year or 2 or 3 or whatever. Also often in contracts of purchase and sale. If I'm an important restaurateur and I've got a successful restaurant and a lot of people come to my restaurant because of my food, and now I sell my restaurant to Narisha, we might include a restraint of trade specifying that for the next 3 years I may not open a restaurant in Windhoek, which makes sense because if she's paying me a whole bunch of money for this contract, and what could happen if there was no restraint of trade is 6 months later, I opened another restaurant, my own restaurant just around the corner, and I steal all her customers. So what is the purpose behind a contract of restraint of trade? It is literally to protect trade secrets and goodwill. Now the question arises, is this contract of restraint of trade legal and enforceable? Because the interesting thing is here that a contract of restraint of trade brings into conflict two constitutional principles. In the first instance, our Namibian Constitution in Article 21 states that all persons shall have the right to practice any profession, carry on any occupation, trade, or business. So you've got the constitutional your guaranteed constitutional right to freely participate in trade. to do any job. And a contract that restricts you from doing a specific job for a specific period of time is literally against your constitutional right to say, which guarantees you the right to freely participate in trade. So, which means it's against the Constitution, it's against the law. From what I just taught you about, performance must be legal. That contract should accordingly be void. On the other hand, there's another principle of public policy that comes in here, namely that contracts it is essential to our free market system that if people enter into contracts, those contracts should be enforced. If you can enter into contracts left, right, and center, and you don't have to perform in terms of them, that is not going to benefit anybody. And a contract in restraint of trade is literally a contract. So you've got these two constitutional principles that are now in conflict with each other. So how does our courts handle issues like this? According to the Namibian courts, and there are plenty of recorded judgments in this regard, our Namibian courts regard contractual commitment is the stronger of the two principles. Which means that a restraint of trade is generally regarded as enforceable unless the person who does not want to be bound must prove that it is unreasonable. So that either the geographical area is too wide, a contract preventing somebody from opening a restaurant in the whole of Southern Africa would be considered unreasonable. Just the district of Windhoek would be reasonable. Time period also a year or two as opposed to 10 years, 15 years. So to summarize, contract of restraint of trade, the issue is it enforceable? Because there are these two constitutional principles that are in conflict with each other. Our courts regard contractual commitment as the stronger of the two principles, and will generally accept that a contract of restraint of trade is enforceable unless one of the parties, the party that does not want to be bound to this contract, can prove that it is unreasonable. And then our last requirement is that in general, formalities should be complied with, or not in general, formalities must be complied with if there are any. But you learned last week that a contract can be totally valid and enforceable, even if it is oral, even if there was not even words spoken. Formality is generally not required, unless it's one of the exceptional cases, like, for example, buying or selling a house. Okay, that is Unit 4, so that is the rest of the requirements. Any questions about Unit 4? By the way, just now while I was teaching, Mrs. K, whoever Mrs. K is, WhatsApp, on the WhatsApp group, can somebody please share the study guide? That is incredibly rude. You are supposed to be in class. I become very annoyed if you send WhatsApps on the group while I am teaching. You can save your WhatsApps till after class, please. Sending WhatsApps while I'm busy teaching gives me the idea that you've just logged into this class, but you're not actually concentrating on what I'm busy teaching you. Okay, no questions about Unit 4. We still have some time left, so I am going to not necessarily finish Unit 5, but I am going to start with Unit 5. This week we're supposed to do, last week we were supposed to do 1 to 4. This week we must do 5, 6, and 7. So in order not to fall too far behind, let's get started with Unit 5. So what we have now is a valid contract. We've learned about the requirements that makes a contract valid. Now we take this valid contract and we learn some more about contracts. And the first thing we look at is terms of a contract. Terms of a contract, the content of a contract. Now we've learned and we understand that contracts can be informal, merely buying a loaf of bread. But even if it's informal, even if you take the loaf of bread from the shelf, take it to the cashier, hand her $12, $15, and that's it. There are terms in this contract. Firstly, we get 3 different types of terms. The first one are your express terms. Your express terms are the essential terms to this contract. So when, who's buying a loaf of bread today? Taimi. When Taimi buys a loaf of bread, even though nothing is spoken, the express terms will be purchase and sale, bread, whatever the bread costs. In a written or oral contract, these are then expressly, specifically agreed upon. Then we also get tacit terms. Tacit terms are not expressed in words, but are essential to the true intention of the parties. So terms that weren't specifically discussed, but without which the contract would not make sense. Let's use the example, who plays sport? I'll be honest, you play sport.
Yes, I do.
What sport do you play?
I play volleyball, ma'am.
Okay, wonderful. So let's say Alvianus is a brilliant volleyball player, and he enters into a contract with volleyball, NUS Volleyball, call them NUS Volleyball. That NUS Volleyball will pay him a certain amount per month to play for them. The express terms of this contract will be that Alvianus will play for NUST and NUST will pay him $5,000 a month. But there will also be certain tacit terms. For example, that he must train with the NUST team. So maybe the contract doesn't specifically expressly stipulate that Alvianus will train with the NUST team. It says he will play for them and they will pay him. If he now suddenly insists on training with UNAM, but playing for NUST and expecting to be paid, you can see yourself, I'll be honest, that won't make sense. And that was not the intention when you entered into this contract. So for the proper execution of your contract, there will be or can be alleged to be a tacit term. So not expressly spoken or written, but required for the proper execution of the contract, that you must also play for practice with NUST. You must also wear their kit, etc., etc. So those are tacit terms, terms that were not express, but are essential for the proper performance of the contract. Whether our courts, our law will impute tacit terms to contracts will depend on the circumstances, general trade usage, etc., etc. In general, our courts are very careful to put words in people's mouths. So they won't easily say, but this and this and this were tacit terms, unless the contract would be impossible to properly perform without them. Then, in addition to tacit terms, we get implied terms. Implied terms are also not expressed in words, but are natural legal consequences which are particular or which flow from a particular type of contract. So the parties don't have to discuss this. It doesn't have to be expressed but it will apply in any event because it is a particular type of contract. We're going to be doing more of them when we get to purchase and sale. For example, a purchase and sale has an implied guarantee against latent defects. So when I sell my car to Fenny, because it's a contract of purchase and sale, there's an implied and unspoken guarantee that the car will not be defective. So even if I kept quiet, I didn't tell her it's in a perfect condition, because it's purchase and sale, that guarantee will. So if the car subsequently breaks down because something was wrong with it, she will have a claim, whether I gave her an express guarantee or not. So these are implied terms. They will always apply to a particular type of contract unless they are specifically So if I sell my car to Fenny and I say to her, no guarantees that there's nothing wrong, then I'm selling it, the term is foot stewards. We'll learn about that when we do purchase and sale. Say to her, so then I have excluded specifically, expressly, has to be expressly excluded. I've expressly excluded these implied terms. They won't apply, otherwise they will always apply. And then you also get incidental terms. Incidental terms, these are your extras that the parties have agreed upon in their particular contract. So if I'm selling my car to Fenny and we agree that she will pay me in installments, payment in installments, that will be an incidental term, something extra that don't apply to all contracts, but that parties are free to agree to, provided that whatever they agree to is legal. Then in the rest of the unit, we look at certain incidental terms. So those are your different types, categories of terms that you get. And then we look at certain incidental terms. The manner that this will be assessed is I will give you the example. I will give you the example and you must tell me what contractual term is this. I will not do it the other way around. I will not ask you to draft let's see, a cancellation clause or draft a warranty or draft a modus or whatever. You are accounting students. I'm not training lawyers. So you don't have to be able to draft the necessary terms, but I will give you the example. And you need to identify them, tell them what they are. So The first one we look at is a condition. Now, I'm sure, give me a quick thumbs up. Sure, you've heard this. Give me a thumbs up if you've heard this. On advertisements on the radio or even in print advertisements, your term is used. They'll say, they advertise something and then they say, T's and C's apply. Have you ever heard them, somebody, or read about T's and C's apply? Getting some thumbs up here. I need to be perfectly honest with you here. I need to put it down here just. T's and C's apply. That is jargon, and I have to confess that it annoys the living daylights out of me. T's and C's apply. That is so stupid. By T's and C's, what they're actually saying is terms and conditions apply. It's a backdoor that people keep open so that you to try to minimize claims against them. If you bought something and that to prevent you from possibly claiming against them, they'll have a warning saying T's and C's apply. Terms and conditions apply. That is rubbish. It is nonsense. It is just bad. Because a condition is a type of contractual term. Terms and conditions are not different things. A condition is an example of a term. But anyway, let me not get worked up at 9 o'clock on a Tuesday evening. What is a condition? What is a condition? A condition is a contractual term. I'm going to do some copy and paste here again. Give me a second. Sorry, I'm with you in a second. Condition is a contractual term that renders the operation and consequences of the contract dependent on the occurrence or non-occurrence of an uncertain future event. So a condition is based on an uncertain future event, something that can or cannot happen in the future, but we do not know if this is going to happen or not. Simple example, who do I have here? Let's use somebody else for a change. Marilise. Oh, now I can't remember how she spells her name. With a Z. Borrow my umbrella. It rains in Windhoek tomorrow. So the uncertain future event is if it rains in Windhoek tomorrow. We don't know whether it is going to rain or not. So that is an agreement. If it rains tomorrow, if it rains in Windhoek tomorrow, is a condition. So she can borrow my umbrella subject to the condition that it rains in Windhoek tomorrow. Raining in Windhoek tomorrow is an uncertain future event. Now we get two types of conditions. We get suspensive conditions and we get, we get resolutive conditions. In both instances, the contract is subject to an uncertain, the occurrence or non-occurrence of an uncertain future event. If the condition is suspensive, that means that it is suspended, it is kept hanging. The operation of the obligations are suspended. Until the happening of this uncertain future event. So this example that we have here, I agree with Marilise that you can borrow my umbrella if it rains in Windhoek tomorrow. That is a suspensive condition. We have an agreement that she can borrow my umbrella. But the obligations, me delivering the umbrella, haven't started yet. They are suspended and they will only become operative. So the contract will only become operative if the condition is fulfilled, if it rains in Windhoek tomorrow. A resolutive condition, on the other hand, is the obligations start. So performance starts, but will stop if the uncertain happens. Let's get an example for you here quickly. So resolutive is to remember that, to resolve something, almost like dissolve, to resolve something. You've resolved the problem, you make the problem going away. Let's see, a quick example. Okay, I've already, let's use Nandekwa here. I hope I pronounce your name correctly. Sorry. House until she fails a course at NUST. So I've agreed with Nandekwa, she can stay in my house until she fails a course. So the obligations have started. She has moved in. Our uncertain future event here is passing or failing. Now, in this particular case, Nandekwa, my apologies. I'm sure you're not going to fail a course at NUST. But it's uncertain. We don't know whether she is going to pass everything or not. So it is resolutive. The obligations have started, but they will come to an end. If she fails, she has to move out. Everybody with me? Or have I lost you? So a condition is a type of contractual term. Don't say T's and C's apply. That is just stupid. Condition is a contractual term which makes the contract dependent on an uncertain future event. It can either be suspensive or resolutive. And then we get time clauses. Now, time clauses are similar to conditions. The difference being that a time clause I'm just looking for my definition here. Okay, I don't have one that I can copy and paste. So I want you to be able to see the difference, then it's going to be easier for you to understand and remember. So a time clause is a contractual term that renders the operation and consequences of a contract dependent on the occurrence of a certain future event. So condition, we don't know whether it's going to happen. A time clause, we are certain that it is going to happen. She could borrow my umbrella. When it rains in Windhoek. That is a suspensive time clause. So time clauses can also be suspensive or resolutive. Suspensive and resolutive means the same, whether it's a condition or a time clause. Suspensive, there's a contract, but the obligations will only start if the future event takes place or when the future event takes place. Condition, we're not sure whether it's going to happen. Time clause, we are sure, even if we don't know when. Suspensive obligations, resolutive obligations start, but will come to an end if or when the future event happens. I agree with Marilee, she could borrow my umbrella when it rains in Windhoek. It is certain. It is going to rain again in Windhoek. Might not be tomorrow, might not be the day after, it might even only be next year. But it is certain that it will rain again in Windhoek. That is a time clause. Resolutive. Time clause. I agree with Nandekwa that she can stay in my house until the end of the year. There is going to be an end of the year. It is a time clause that is a future event. It is certain that it is going to happen. Questions about this? My parting words for this evening. Still a little bit early, but I'm going to stop here. I'll look at the rest of the terms on Tuesday. Let this sink in. The rest is easy. Whether the rest of the terms of a contract, as I said, you have to identify them. That's pretty much memorization. This is the only actual part of Unit 5 that requires understanding and application. Each of the following instances indicate whether the contract is subject to condition or time clause. Expensive or resolutive. So I give you the example. You must determine this future event. Is it certain that it's going to happen or not? If it's certain that it's going to happen, it's a time clause. If it's not certain that it's going to happen, it's a condition. Indicate whether it's a condition or a time clause, and then whether it is suspensive or resolutive. The performance, will the performance only start at a later stage, or has performance started? Resolutive and will come to an end. Okay, is everybody with me?
Yes, Miss.
Wonderful. Thank you, Lucia.
Yes, Miss.
Okay, lovely. Thank you so much. That's it for tonight. I will see you then on Thursday again. Let me stop the recording. Alvianus, your hand is up.
Oh, my apologies, ma'am. I accidentally pressed it. My
Okay.
apologies.
Good evening, ma'am.
Yes.